May it please the court, counsel. I would like to reserve 5 minutes of rebuttal.
Thank you.
My name is David Sokol, and I represent the appellant, Christopher Dixon, who was the respondent in a domestic violence injunction. The issue I'm going to be discussing with the court today is whether it was appropriate for the trial court to enter an injunction where there was no evidence of any recent domestic violence allegations, nor was the fear reasonable in the petitioner at the time the injunction was entered. The facts of this case are the petitioner and the respondent had been married for several years. They were divorced in 2010. There was virtually no contact between the petitioner and the respondent until 2013. In 2013, the respondent's family had filed a malpractice action against the petitioner. That had caused a little bit of disharmony between the two of them, and some resulting court cases and contact. There was also the respondent's family had started a not-for-profit corporation that was doing some events involving the 600 block in downtown St. Petersburg for the art community. That was the first contact between the respondent and the petitioner in the 3 years. And that contact came in the form of the respondent walking around with a professor from USF who was in charge of the Sunscreen Film Festival, contacting the businesses along the 600 block of Central Avenue, getting their permission to shut down the block and hold a fundraiser during the Sunscreen Film Festival. During that time, the respondent walked into a business and art studio which was run by the petitioner's boyfriend, and which he subsequently found out the petitioner claimed to have an ownership interest in, and asked their permission to sign on the petition to shut down the 600 block. During that time, there was no altercation. The boyfriend was fine, everything was cordial, and in fact the boyfriend did sign the petition authorizing the respondent to hold this event on the 600 block. Approximately a month later, the respondent and the petitioner were in court in Tampa during a hearing on the malpractice case. That hearing was held in chambers. Present with the respondent was his attorney. There was another attorney representing one of the other parties, and on behalf of the petitioner's side, there was her attorney, there was another attorney from her office, her boyfriend was there, and it was sort of a crowded chambers. The reason why this is relevant is this injunction is based upon two allegations. As the court knows, when you file for an injunction, the initial procedure is ex parte. So all the petitioner had to do as an attorney was to allege some incidents of domestic violence back from 2010 and previous, and then say that she was in reasonable fear, and the judge initially, without a hearing, enters the ex parte injunction. During the hearing that was conducted, the petitioner then had to prove up why she was in reasonable fear or that she was the victim of domestic violence. During that hearing, there was no evidence whatsoever of any incidents or allegations of domestic violence since 2010. Since the parties had been divorced, there had been no contact. The petitioner called herself and 4 other witnesses, her mother, her sister, her boyfriend, and the attorney who attended the hearing in Tampa. The petitioner testified as to allegations in 2010, but said the only incidents that had occurred recently was one at an event one night about 2 weeks after the respondent had gone to see her boyfriend and gotten permission to have this block. He was attending an art opening on that street. He was there with his family, a date, and a family member, and they walked by and stood outside of, the allegation was that they stood outside the art gallery that was being run by the petitioner's boyfriend, and that he stood there staring at her, giving her that look of a threatening look. The testimony was that night that he actually was with his parents, and that they in fact had an office that they had opened on that block. A year before that, and they were totally unaware that her boyfriend had an art studio on that gallery, that they had done everything for the past 2 or 3 years to stay away from him. But that was the only incident of the stalking or
Counsel,
alleged.
if this was a contention that there was the only way to get the injunction was through reasonable fear, there's a line of cases that suggests that mere harassment would not be enough. Would you agree with that?
Yes, absolutely.
So then, would it be necessary for the trial court analytically to consider the past incidences asserted of domestic violence in order to measure whether or not the fear is reasonable? In this case, she mentioned threats of death, placing a gun in her mouth, and other acts and threats against family. Would that be within the realm of evidentiary facts that the trial court could evaluate in determining whether or not this is a reasonable fear?
Yes, the trial should do that, and it is supposed to do that, but at the same time, they're entitled to look at the history between the parties, and that's what this court has said in many cases, and to see how that relates to it being reasonable. Of note was, of all those prior allegations of domestic violence, not once was there ever an incident, only on one time, and that was on cross-examination, did the petitioner acknowledge that the police had been called, and that in fact at one time when they were married, where the police were called during the incident, they were not called until several hours after, and the police found that to be unfounded and did not find any evidence of domestic violence, and that was gone. That was 3 years prior, 3.5 years prior. So I think that the relevance then in terms of for this court to determine is 3 years later with no contact, is it reasonable to still have that fear when you have not had any contact for 3 years, and then now the only thing is somebody standing outside in an area, in a public street where they were there for a specific legal legitimate purpose, one and attending a gallery opening a couple of doors down and then having dinner right down the street. So that was the testimony at trial. I mean, during the hearing, as I was saying, Your Honors, she testified to those prior incidents, but then there was nothing, no threats, no recent threats. Now in the petition, the ex parte petition, she said there had been recent threats, and she also said that there had been emails. No evidence of any recent threats. She also testified that there were recent threats to her boyfriend. No evidence by the boyfriend actually testified there were none.
Perhaps because the trial court said she already had the petition before her and only wanted to hear what? Well, but perhaps not, because maybe she said she wanted to hear all the current stuff, but not the old stuff. Okay.
That's correct. Yeah, and I think that was a correct determination by the court. I mean, she was familiar, she had read the file, but it's the standard set forth by the second DCA and the other courts within Florida is that you have to look towards the recent activity, and if something is far removed, where you're dealing with a situation where an isolated incident years ago, that should not be the basis for the injunction. The court has to determine whether the basis and the fear of imminent harm is reasonable from an objectively reasonable standpoint that is taking place at the time the injunction is being asked for. And it's our contention that the evidence, the two incidents that were alleged to have been recent, one is standing outside the art studio where nothing was said, and clearly the respondent was with other people. This is not the situation where you have the husband outside the home, stalking, sitting outside, I'm watching you. This was a public area where clearly the testimony was there was an opening of another art gallery a couple doors down. Naturally, there's a flow into the street, and then walking to dinner and walking back, which is why, and in fact, Mr. Blicken, her boyfriend, when he testified, he said there had never been a threat to him the entire time, and that he did not feel intimidated when he came in and gave permission for the respondent to host this event outside, and knowing that he was the main guy putting on this event for the entire block. He did not feel at that point any problem. And this is only 3 weeks before, a month before. This is in February when he gave permission for them to hold the event, which presumably benefited everybody on the block because it was bringing all these people to these the art galleries on that street. And it's mostly art galleries on that street. And then you had the petitioner's mother testify, and she was then asked. She could not testify to one incident ever, even in their long marital relationship, of any time that she ever was or knew or witnessed any domestic violence. She did testify and she had heard about that prior incident, but that was it. And so she knew of nothing recent during the past 3 or 4 years. And then they also called the petitioner's sister, and she testified by telephone. And the petitioner's sister said, I have not had any contact with the respondent in over 4 years. I have no personal knowledge. So the question becomes, you're now faced with where is the reasonableness of this objective fear? The next issue becomes now the court hearing. In that court hearing, where it's crowded chambers, and everybody's in there, Mr. Blicken testified that he's 6'5", and he sat actually in that hearing behind the respondent during the hearing, right? And then it was a crowded chambers, and the only allegation that was used as the basis for the reasonable fear was that during that hearing that the respondent made threatening remarks to the petitioner. And then as she went to leave, he blocked the egress of the chambers. And on cross-examination, and even on direct examination, she never testified to one threat that was actually made. She just used the word threats were made. But there was never any testimony. He said, I will do this. He said, I will do that. He said, I'm coming to do this. No threats were made during that hearing. The only issue is, that the witnesses testified to, was that he was within her space. And that because of that, that was intimidating. And on cross-examination, it was acknowledged that nothing was said by the bailiff, nothing was said to the judge, nothing was said to the other attorneys. With all these other people there present, 10 people in a chambers, that this was that type of an intimidating thing. No other witness testified to that, and it was only that the space was close. And that space being close and standing outside and no allegations of domestic violence for 3 or 4 years does not rise to the level of a reasonable fear, as this court has set forth. As the court stated in the Jones case back in 2010, mere fear by the person, where that was the issue where the husband had been in special forces and said that he knew, how to talked about harming people, similar to the allegations that have been made here of his family's in police.
Can Jones be distinguished because in Jones, if I recall correctly, there was no evidence of any prior domestic violence act? I think there's a notation there around head note 3?
Yes, that's correct.
Can that case be distinguished on the basis of that sentence, so to speak?
It can, Your Honor, because there was, but in this case, I still think that the proximity of it, and I was using that analogy simply because that case has been cited actually by the court last week, but the reasonableness of, do you have to be, the fear has got to be reasonable.
It would be that in Jones there was no testimony, and in this case the testimony is so old as to be stale.
That's correct, Your Honor. The Jones is similar because you're still talking about the events, and in Jones they actually talked about having to be there. His reason for being outside the art studio was a legitimate reason to be there. His office, Chart 4111, did have an office on that block. They were promoting this. So this is not a thing where he was supposed to be there, and that's similar to those facts in Jones. Similar, as Judge Cusnova, you were opined in the SCV-AD case, 2nd DCA 2011, you're dealing with a 2004 injunction had been granted, and then they continued to renew the injunction, and they used a 2004 incident in a 2009 injunction, and as this court stated, that the fear alone is not the reasonable cause alleged to support it. And the rationale for the fear has to be objectively reasonable. In this case, we would suggest that the rationale for the fear was not objectively reasonable, given absolutely no contact. And then there was even testimony during the hearing that at events, both of these people continue to reside in downtown St. Petersburg, close proximity. There's not that many things going on. They're both very active in the community. The petitioner is active and actually sought an injunction to keep the petitioner away from the Chamber of Commerce building, which is directly across the street from...
I need to tell you you're at 15.
Okay, thank you. Directly across the street from where the Sunscreen Film Festival was being held. Once again, I think you can look towards the intent in getting the injunction and the timing of it, of what was going on. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
It's a little bit difficult. My name is Lisa Wilcox. I'm pro se, representing myself today. The difficulty with the domestic violence injunction and admitting to the court that you are a victim has brought me a great amount of strife in my life and stress, and I apologize today for getting emotional here. It's not typical in our practice to show emotion, so I apologize in advance, Your Honors.
Would you prefer that I refer to you as counsel?
Yes.
Since you are an attorney.
Thank you, Your
Counsel,
Honor.
I do have a question for you. Perhaps
Yes.
that will help you get into your argument. As I look at the evidence in this case, one of the things that we always keep in mind at this level is we are not the trier of fact. And so the question that I have is, we are not going to be allowed to reweigh the evidence. So your position must be that the evidence that was adduced meets a legally sufficient prima facie case. Is that correct?
Yes, Your Honor.
And is your argument that it's not merely fear, it's fear coupled with past incidences?
Yes, Your Honor. And that the statute 740.301 specifically says or, acts of violence or, and once the trial judge finds that there are the acts of violence, you've met the prima facie case for a petition for domestic violence injunction. That coupled with most of the cases that have been cited, the petitioner alleged in the petition that they filed an act of violence, but then recanted those acts when they testified at the trial. So my position is that there was enough of a basis to find the domestic violence injunction based on the prior acts of violence. With respect to whether or not the fear was there was a reasonable basis for finding imminent fear, what counsel has failed to mention with recounting the facts is that his client positioned his office not only next to the studio where I was a partner of, but also by my office, within a block of my office as well, my law office that had been there for several years. So it's a combination of several factors, and the abuse, the emotional abuse, and the physical abuse that led to the necessity of filing the petition. And there was not just the divorce was over, there had been a bar complaint filed, there had been several other things that had taken place in that time period. And whether or not the acts of violence, the time period was too far removed, there have been cases where the acts of violence were 10 to 12 years later, and the court still found that the petition filed was sufficient to support the issuance of an injunction, and that was in the case of Gilianza v. Gilianza. And so it's my position that that the court did find a prima facie case and had for entering the petition for domestic violence.
Thank you. Thank you.
You know, one of the issues here is if you're going to rely upon the prior acts, you cannot, there has to have been a finding that there actually was prior domestic violence. And in this case, there is now a finding. The trial judge cannot make that finding. The only thing the trial judge did was make a note that there were allegations of prior domestic violence, but there was never one. So unlike any of those cases, there only one time in their previous 15-year relationship where the police ever called, and it is undisputed that as a result of that investigation by that officer, that there were no charges were ever filed and there was no evidence of domestic violence found during that one time.
Well, let me ask you this. Is our standard of review whether it's competent, substantial evidence to support the trial court's conclusions? Because the trial court comes up with a presumption of correctness. So my question is, the argument you're making at this point, if I understand it correctly, is that there's a technical failing in the court's order to say, I find the following facts to be true, or I find this person incredible. If our standard of review is to look at the evidence that was adduced to support the trial court's presumption, then, and given the inference to the trial court, then it would be finding that the testimony was credible and to support those things. That's my concern. We're not allowed to reweigh. I want to give you a chance before you leave to address that.
Yeah, no, I mean, I think there's a presumption of correctness, but there is no competent, substantial evidence to support that there was prior. There was merely allegations. And there's a difference between an allegation of prior domestic violence and a finding where there had been evidence of prior domestic violence. And that's how this case is distinguishable. And this is similar to the case handled by Judge Kelly in the Cower case, where at the actual hearing itself, to get the petition, there were several incidents were raised, but at the actual hearing itself, only one of the 6 incidents were testified to. There was lots of stuff in this petition that never came out during the trial in terms of substantiating it, that being the threats and the emails. So the concern we have here obviously is when you get into that situation where now you have the domestic violence, as this court has said, it's not the unintended consequences. The purpose of this law was to protect a victim in a domestic situation from domestic violence, and that was based upon either prior domestic violence or a reasonable fear. It was not intended to be used as a sword to go out knowing you're in the middle of a malpractice case and go out and get an injunction and say, I'm going to shut down you and make sure you cannot go to this event that you are hosting where my boyfriend has given permission for you to attend, knowing that this has been planned for 6 months. There are vendors, entertainers, lots of people, fundraisers, contributors, all types of people invited to this event and enjoying him from that event, and also at the same time throw in the Chamber of Commerce, knowing the Chamber of Commerce is located directly across the street from Baywalk movie theaters, where all of the sunscreen film events were being held, so that you cannot go to that event, targeting those 2 events. This is what's happened. This was used as a sword, and the basis for it was an allegation of standing outside on a public street, knowing there was an event, and an allegation that there was close quarters inside the courtroom. Based upon that, we respectfully request that the trial court be reversed and that the court find that there was no reasonable standard to find that either domestic violence had occurred, because they used, in the court's order, she uses the disjunctive, I find domestic violence has occurred, or that the petitioner is in reasonable fear. And in this case, there was no testimony of that domestic violence. There was allegations years ago, and that certainly was not the standard that evidence was taken on during this hearing. And so the next issue becomes, is the fear reasonable? And even though they used the form order.
You need to wrap up, your time
has
expired.
And so we would respectfully request that the court be reversed. Thank you.
Thank you. Thank you both.